Parol Evidence Rule Part 2, Ambiguity. Some people think of ambiguity as an exception, perhaps the most important one to the PER, while others conceive of it as a prong of the PER. Either way, under classical contract doctrine, if a party could identify an ambiguity in one of the terms of the written contract, the PER did not apply to evidence submitted for the purpose of resolving that ambiguity. So, for example, Section 214 subsection C of the Second Restatement states, see also Comment B to the section. According to classical contract doctrine, whether or not an ambiguity exists is a question of law to be determined by the judge. Once the judge determines that there is an ambiguity, the meaning of the ambiguous word or phrase is a question of fact. So in practice, this means that before the extrinsic evidence can be admitted at trial, the judge must make a prior determination that there is an ambiguity in the contract. In the case of a bench trial, where the judge is sitting as both judge and fact finder, this isn't a problem. When a party argues that there is an ambiguity, the judge decides whether there is one, and then either goes on to decide how to resolve the ambiguity, or ignores all the evidence about what the term means, and decides the case solely on the basis of the judge's interpretation of the written words. This bifurcation of law and fact does become problematic in the context of a jury trial. In that case, either before the trial begins, or if the issue arises for the first time during trial, during a break in the trial, the judge, without the jury present, hears arguments from counsel, perhaps takes evidence, and more on that to follow, and decides the legal issue of whether there is or is not an ambiguity. In essence, there has to be a kind of a mini-trial before or in the middle of the main proceeding. If the judge determines that there is an ambiguity, the same arguments and evidence will then be presented to the jury, who will decide which of the two meanings to accept. If, however, the judge determines that there is no ambiguity, the evidence is not presented to the jury because there's nothing for them to decide. They will have to resolve whether and how the contract should be enforced based only upon the jury's interpretation of the written words. Some scholars and judges have argued that this bifurcation of law and fact, which we'll also see in the context of integration, reflects a fundamental distrust of juries. They point out that we trust the judge to ignore the evidence if she decides there is no ambiguity and decide the case solely on the basis of the written contract, but apparently we don't trust juries to be able to do the same. Saying that ambiguity is a question of law gives the judge a lot of control over what the jury hears. The judge, in practice, gets to preview the evidence and evaluate its credibility. The suspicion is that if the judge finds the evidence credible, she will determine there is an ambiguity and allow the jury to hear the evidence. Conversely, if she disbelieves the evidence, she will determine there is no ambiguity, and the jury will never even hear the evidence. Ordinarily, we say credibility is something for the jury to determine, but in the case of ambiguity, we give the judge the first crack at evaluating credibility. Classical contract doctrine sought to mitigate this problem by requiring the judge to decide whether or not an ambiguity existed solely on the basis of the writing itself. This has been called the plain meaning doctrine, also sometimes referred to as the four corners approach. The judge looks at the written contract and decides whether or not there is an ambiguity, based solely on the judge's own interpretation of the words. There is no problem of the judge evaluating credibility, because the judge does not listen to any evidence. But this, of course, is problematic in another way. What is plain to one person may be ambiguous to another, depending on each person's experience, education, and understanding of the context. Opponents of the plain meaning doctrine argue that it puts too much belief in the ability of words to convey ideas unambiguously. The plain meaning doctrine suffers from another problem. Sometimes the ambiguity is not obvious on the face of the writing. There's a notorious case from the 19th century involving a fight over the proceeds of a life insurance policy. A man died with a life insurance policy naming "my wife" as the beneficiary. At the time of his death, the man appeared to be married to one woman, but after his death, it was discovered that he was a bigamist. He had been married before and had abandoned his legal wife, changed his name, and remarried. If you didn't know he was a bigamist, the designation of my wife seemed unambiguous. He was known to be married to Mrs. X. But once extrinsic evidence of his bigamy was introduced, my wife became deeply ambiguous. Did he mean the woman everyone thought he was married to? Or did he mean his abandoned but only legal wife? While there is consensus on the principle that ambiguity is a question of law to be determined by the judge, there is not now and never has been consensus on how the judge should go about deciding whether ambiguity exists. So today, you can still find judges using the plain meaning approach. That said, however, there seems to be a slowly emerging middle ground approach that seeks to avoid both the problem of too much reliance on the words without hearing their context, and the problem of allowing the judge to decide whether she believes the evidence. This middle ground approach says that the judge's function is to determine whether the language involved could reasonably be subject to different interpretations. If so, the extrinsic evidence is admitted. This standard of reasonableness allows the judge to exclude the evidence if the judge determines that the proposed interpretation is unbelievable, say that up means down. In other words, the question for the judge is not, do I think this interpretation is credible, but rather, could any reasonable person find this interpretation credible? But the reasonable standard also requires the judge to consider more than just the words of the contract. The judge must consider the words in the context of the party's situation. And to understand that context, the judge may have to hear testimony from the parties outside of the hearing of the jury. This is the approach taken by the Arizona court in the Taylor case in the text. It is also the approach adopted by Utah and other states. The UCC has taken a completely different tack in addressing the question of ambiguity. It jettisoned the whole question of ambiguity and instead focused on the kind of extrinsic evidence involved. So, Section 2-202 of the UCC states that written terms may be explained or supplemented. Official comment number 1 further states, so in UCC cases, if the extrinsic evidence falls into one of the 3 categories, trade usage, course of dealing, or course of performance, that evidence is always admissible to explain or supplement the contract. The rationale behind this rule is that these kinds of extrinsic evidence are highly reliable. They are not subject to the vagaries of memory, unlike remembered conversations, and are not easy to manufacture, unlike lies about what was said. The UCC, however, is silent about the admissibility of other kinds of evidence, such as remembered conversations, which means that for these other kinds of evidence, the judge has to look upon state law on an ambiguity. So, for example, if one party in a case involving a sale of goods, and thus governed by the UCC, wants to admit evidence of trade usage, say through the use of an industry expert, and wants to testify as to a conversation that occurred at the signing of the contract, UCC Section 2-202 would freely admit the trade usage testimony without any finding of ambiguity. But before the party's testimony about the conversation could be admitted, the judge would have to first determine there was an ambiguity.